here in Colorado, here in this state, in the Centennial State, we have a Bill of Rights that guarantees our right to keep and bear arms, and that we can at least, at the bare minimum, the floor of a Coloradan's right to keep and bear arms is that we can own pistols and rifles and shotguns in defense of home, person, property. Let me say it again. The floor to a Coloradan's right to keep and bear arms is that we can own pistols, rifles, and shotguns in defense of home, person, and property. So we have the Rocky Mountain gun owners versus Jared Polis case. The Supreme Court is going to uphold HB 1224, which I think was an old 2017 law or some shit that the General Assembly had passed. HB 1224 bans gun magazines that hold more than 15 rounds. So the Rocky Mountain gun owner case is actually weak to begin with. They're not even trying to, go after the damn law, the whole law. They're just saying that one part of the law where they banned magazines and the removable base pads, they said that encompassed to a ban on all magazines. And magazines is just, where the ammunition is held. So when it comes to regulating assault rifles, anyways, they messed up. They only sued for that reason and that reason only. And they messed up because in the law, CRS 1812-301 2AI, HB 1224 turned into CRS 1812-301 2AI, it defined all large capacity magazines as magazines that can be readily converted to accept more than 15 rounds of ammunition. So the definition of large, they said it was an all-out ban. The Supreme Court, correctly said that their stupid-ass argument was wrong. Because by defining large capacity magazine as anything that can hold more than 15 rounds of ammunition, they defined it. That's not a ban on all magazines, because if a magazine can hold 15 rounds, 14, 13, 12 rounds, then it's A-OK. It's A-OK. So the gun owners case, gun owners v. Jared Polis 2020, is going to be a loss for the gun owners, the Rocky Mountain gun owners themselves and the gun owners of Colorado. So gun owners are going to lose the 2020 gun owners decision. And it was a unanimous decision, and it was a 2013 statute. And it's section 18-12-301 at sequential. So all that shit past 18-12-301. So the Supreme Court of Colorado unanimously said that they banned, 15 rounds, over 15 rounds assault rifles. So therefore it's not an outright ban. They covered their asses fucking beautifully. Fucking perfect. Almost perfect. Almost perfect. Now, where the Supreme Court of Colorado fucked up, and they fucked up big time, is that instead of combining both Colorado's right to bear arms and America's, they said since the defendant didn't specifically ask to be protected under the U.S. Constitution, the Colorado Supreme Court has only considered the large capacity magazine question only under the Colorado Constitution. They said, when interpreting our own Constitution, we do not stand on the federal floor. We are in our own house. Again, the floor to keep and bear arms in defense of home, person, and property. We get to keep pistols, shotguns, and rifles. That's the floor. That's the floor. So, because the plaintiffs in the gun owners' decision didn't specifically invoke the Second Amendment, Colorado Supreme Court only used Article 2, Section 13 of Colorado Constitution to consider the 2020 gun owners' decision. Well, this leaves a large gaping hole, does it not? It's a wonder why the plaintiffs didn't file the case again, only this time adding the Second Amendment to their goddamn defense. The Supreme Court of Colorado just wistfully says, we're going to ignore the U.S. Constitution, just interpret the Colorado Constitution however they wish. But without irony, they cite a U.S. federal court case, Minnesota v. National Tea Company, U.S. 1940, in their defense. This Minnesota case has to do with the National Tea Company had paid 2 years worth of taxes on a tax that was illegal, and they got all those taxes refunded back to them. So what are you talking about, goddamn Colorado Supreme Court? Well, the reason why we get to ignore the U.S. Constitution was because in Minnesota v. National Tea Company in 1940 U.S. Supreme Court case, when it comes to case law, Colorado Supreme Court needs to just look at Colorado case law, not, U.S. case law. If they're going to ignore the Second Amendment, if they're going to ignore the 14th Amendment, if they're going to ignore the U.S. Constitution, if they're going to ignore all the laws of America and just interpret this, lawsuit based upon Article 2, Section 13, which I think they got that wrong too, since they didn't combine the two rights. They don't have a very crystal clear picture. I think the Supreme Court of Colorado, they wanted to go into a place where the plaintiffs have never been. The plaintiffs knew the Second Amendment, but they didn't know Colorado law. So the Supreme Court took the plaintiffs to Colorado law, and they wind up beating them with Colorado law, even though there's no reason that they should have. The language of Article 2, Section 13 has been the exact same language since 1876. We have a right to bear arms in Colorado. We have an individual right. We don't need the Heller and the, McDonald decision, which plaintiffs allege that the federal McDonald decision overruled the state Robertson decision, a 1994 Colorado Supreme Court. And I believe the Robertson decision overruled a Denver law banning assault rifles. So it allowed citizens in Denver to own an assault rifle. So why would the plaintiffs are just fucking up left and right. But it seems weird to me that if you had a situation, Kyle Rittenhouse, he goes to court and he says, I fought for my, self-defense. But the Supreme Court of Colorado would say, okay, you fought for self-defense under Colorado law, not under American law. So therefore, we got to, do what the Colorado Constitution and the Colorado legislative statutes and the cases, the judicial branch, their opinions. That's what you got to, that's a good trifecta, at least to understanding a good bulk of Colorado law. The language of Article 2, Section 13 also says we can't have carried concealed, but we've, gotten around that exception. If you get a permit from the sheriff, then you're allowed to have carried concealed. So I think it's, super fucked up. If Kyle Rittenhouse goes to a Colorado court and he says, I, fought for self-defense, but he didn't say I fought for self-defense as indicated by the Second Amendment of the U.S. Constitution, then all the laws of America are null and void, and it's just Colorado law, except for the random U.S. Supreme Court cases that the Colorado Supreme Court uses for case law. So in gun owners, here's what the Supreme Court wrote in the 2020 gun owners decision. Had plaintiffs wished to have their allegations judged under Heller or McDonald, they could have raised a claim under the Second Amendment, but they chose to challenge HB 1224 solely on state constitutional grounds. Had plaintiffs brought a Second Amendment claim, we would, of course, be bound by the U.S. Supreme Court's interpretation of that provision. But that is because we would be enforcing a right guaranteed under the federal constitution, not a right under our state constitution. Whoa! Colorado Supreme Court, my God, you pulled. This is, my God, talk about Jesus. Fuck. Gun owners v. Jared Polis, they're still going after the red flag law, but they're challenging it on legislative procedural grounds. So who knows where that will go. Jared Polis tried to get this new case dismissed under CRCP Section 12B1 and CRCP Section 12B5 because they're different. One says that you can consider evidence outside the case when you mull over a motion. The other one says that you cannot. There's 3 parts to the magazine ban. It's 18-12-302. is a large capacity ban. Even if the gun owner decision passed, it doesn't override all these, anti-gun laws that has been passed. They were only looking at their business interest and thinking, well, shit, we can't sell our machine guns that has magazines, up to fucking, that can hold 50 bullets and shit. So maybe Colorado Supreme Court don't understand the Heller and the McDonald decision. The Heller decision says that the Second Amendment means we got an individual right to bear arms. And then the McDonald decision says that via the 14th Amendment, the individual right to bear arms applies to all the states. And not just for the Second Amendment, but for all of our Bill of Rights. All of our rights and freedoms via the 14th Amendment are protected. That's the implications of the McDonald and the Heller decision, which are talked about together. The 2008 Heller decision, the 2010 McDonald decision. And it's Scalia, right? It's Scalia and Amy Coney Barrett. So after Heller, they didn't know if it was just, I think in D.C., McDonald's in Minnesota, so therefore the Second Amendment applies to all of America, for all Americans. But we didn't actually need that here in Colorado because we have an individual right to bear arms. We also have a right to join in with the posse comitatus. But we can't carry concealed weapons. That's what our right to keep and bear arms, Colorado's rights in the Bill of Rights in the Colorado Constitution, that's what it says. Specifically, Colorado's Second Amendment says this, Section 13, right to bear arms, the right of no person to keep and bear arms in defense of his home, person, and property, or in aid of the civil power, when thereto legally summoned, shall be called into question. You can't even call it into question. My right to keep and bear arms in defense of my home, person, and property, can't even call that shit into question when the civil power, when the sheriff says, hey, I need you to join my posse comitatus, when the commissioners, when the civil power legally summon me, then I also shall carry my gun out into battle to go get the damn felon motherfuckers. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons. So that's Colorado's Second Amendment, quote unquote, Second Amendment. And so, when it comes to Colorado's gun owner decision, I just can't believe that the Colorado Supreme Court got it so goddamn wrong. Colorado Supreme Court, they didn't recognize our Second Amendment rights. So what about our 14th Amendment, right? Well, they ignored that too. So they're ignoring our 14th Amendment, our Second Amendment. What about our First Amendment, our Third Amendment? What about our 12th Amendment, 7th Amendment? We got to go to federal goddamn court. We got to go to federal court just to get our Bill of Rights upheld. That's insane. Does Colorado recognize any of the U.S. Constitution? Is Colorado's Supreme Court contemplating secession? Do they just don't, when I drove into Colorado, did I drive out of America? Now, there's two different theories, or three different theories, probably infinite different theories. But the main theory is that we are a federalist society. We are a collection of states, a union, United States of America. And then whatever the U.S. Constitution does not cover, then the Colorado Constitution, the state constitution, will, take over. So the U.S. Constitution only claims a few powers. The Colorado Constitution claims all the rest. Now, perhaps Colorado Supreme Court ignores U.S. law. Maybe they ignore home rule too. I don't know. Maybe do they even, where do they place case law and common law compared to the legislative statutes in the Constitution? And I don't see how everybody wants to say freedom isn't absolute in Colorado. How can power be? If freedom isn't absolute, then neither is police power. And of course, absolute power corrupts absolutely. Gun rights have been with Englishmen since 1689, the Protestant Bill of Rights. It protected an individual citizen's right to own and carry arms. Now, the power of the posse comitatus comes from common law. The origins are in common law. But it's constitutional law in Colorado because it's part of the Bill of Rights. It's part of the Constitution. Article 2, Section 13. So common law there is a definition of common law in Colorado code, but in Colorado's criminal code, Title 18 says fuck common law. You don't need the damn you can't punish anybody because of common law. Nobody can be punished because there's a specific body of law for common law marriages. But if you actually really need the color of law to fill in the gaps to the law, then look to executive orders, conduct codes, common sense. So there you go. I don't understand Colorado's Supreme Court, how they're going to sit there and make the U.S. Constitution null and void, and they ignore the Bill of Rights, and we have a right to revolution unless it's repugnant to the U.S. Constitution. So we have to do it in the name of America. And hell, do it in the name of Colorado too. So you have a revolution, it's in the name of America, name of Colorado. That's not repugnant to the Constitution. You know what is repugnant to the Constitution? Ignoring the Constitution, pretending that the rights and freedoms that all Coloradans have and guaranteed and protected by under U.S. law actually isn't Colorado law. Of course it is. The U.S. Bill of Rights is a part of Colorado law. Because federalism in regards to rights and freedoms means that both of our Bill of Rights, you combine Colorado and America's Bill of Rights, and that's the basket of freedoms that we all get. The U.S. Constitution, you might have it, maybe Colorado is over the U.S. is over Colorado. Maybe the home rule cities are over Colorado and the U.S. But the general definition for America, for Colorado in America, is that, our republic, our Coloradan republic, in terms of rights and freedoms, we get both the U.S. Bill of Rights and the Colorado Bill of Rights. So when the gun owner decision that the Supreme Court issued said that, well, you just didn't say, you should be covered under the Second Amendment, that's so stupid. It's almost like you shook somebody's hand and you said, okay, you got the right to free speech, the right to assemble, the right to bear arms, the right to, the Third Amendment, no soldiers quartering. You got all these baskets of right. They're shaking your hand and saying, okay, you got all those rights and freedoms, but they were crossing their fingers behind their back. Psych, you actually don't have the rights and freedoms under U.S. law. You only got the rights and freedoms under the Colorado Constitution unless you specifically say that you were fighting for self-defense under, So for a affirmative self-defense, for affirmative defense, you would have to say, I was fighting, if you're Rittenhouse, you'd have to say that I was fighting in self-defense under the U.S. Constitution, under the Colorado Constitution, under the case laws, under any of the code, any of the trifecta, the big three, or any other law that's anywhere else that, under the sun that says that I have a right to defend myself. Anywhere where those laws are written, that's Colorado law. And the right to self-defense and natural law comes from the right of self-preservation. Last but not least, all these famous Supreme Court cases, you got the People v. Garcia. You got, Garcia v. the People. They just kept fighting poor Garcia. But you have all these Supreme Court cases. You have the People v. Garcia, 1979. You have the People v. Blue, 1975. And People v. Ford, 1977. The people, it's the state. The state is pretending that they're the people. And if Ford isn't a citizen of the people, who the fuck is he? Ford comes into Colorado and attacks the poor people? No. The state came after Ford. The state came after Blue. And the state came after Garcia. Sometimes in the defense of people, but sometimes just in the defense of themselves. So I can't stand the names of many of these Colorado Supreme Court cases. They're not accurate. It should be the state versus Blue, the state versus Ford, the state versus Garcia. By saying it's the people, it's propaganda, and it makes it seem like not only is the government is just doing what the people want, right? Well, like when Jesus was killed and Pontius Pilate says to the Jews, and the Jews said, crucify him, right? So this is just Pontius Pilate scapegoating the Jews, saying it was their fault. The people are making us. The people before, the people wanted this. Did the people want this, or did a couple motherfuckers in the system, a couple goddamn, members of the Leviathan, did the state? It was the state that wanted it. Come on, give us a goddamn break. So like I said, if a citizen isn't part of, who is a citizen if they're not a body of the persons that we call the people? I'm a citizen. I'm part of the people. They're the government. So that's the state versus a citizen of the people. But they're saying that they're the people, they're the government. They're fucking everything, aren't they? Isn't they? They sure are. So the floor to Coloradans' right to keep and bear arms is that we can own pistols, rifles, and shotguns in defense of home, person, and property. When it comes to the castle law in defense of home, we got an extreme, not absolute, right to defend our castle. When it comes to defense of person, stand our ground, we got an extreme, not absolute, right to stand our ground in defense of person or persons, other people. We also have a maximum or an extreme right to bear arms in defense of property. The floor is we have a right to defend our property, our person, our home, other people's persons, and we can own pistols, rifles, and shotguns at the bare minimum, at the very least. That's what Article 2, Section 13 guarantees to we the people. So the gun owner decision might have been correct in the way that the plaintiffs wrote the damn thing up, but if the damn plaintiffs would have had any of the public in mind, they should refile the damn case. Say that the Second Amendment applies in goddamn Colorado, because it does. Well, you drove out of America. No, you don't have a right to peacefully assemble. You can only peacefully assemble the way. Motherfucker. As a Colorado American, actually, I like that our basket of rights and freedoms have been expanded. And it's unfortunate that the Colorado Supreme Court, unless you specifically say, I have a right to peacefully assemble under Section 1, Verse 2 in the First Amendment of the U.S. Constitution, and then, of course, the case law, then, of course, CRS. Unless you say all of that, if you just say, hey, I have a right to peacefully assemble, period, and not define it, maybe, I don't know. Well, that's assumed it's under natural law, is it? So yeah, the Colorado Supreme Court, their justification, their reasoning for the gun owner decision, it makes sense. 15 bullets, they did define it. They were just going after the large magazine ban. But if it was something more fucking important, ignoring the Second, we're just going to put the Second Amendment off to the side when we're deciding this case. If you put the Second Amendment off to the side, have you put any of those rights and freedoms together? Because our basket of freedoms comes from, not just the Bill of Rights of Colorado and U.S., but it comes from the body of the Constitution. There's a right to recall an initiative that comes from the body of Colorado Constitution. We, the citizens of Colorado, have a right to begin initiatives. We, the citizens of Colorado, have a right to throw any of our public officials, any of these goddamn bums out on their fucking asses, provided we get the signatures and, the replacement person and all the rest. So our basket of freedoms are expanded because of federalism, which says that both the U.S. and the Colorado Constitution apply. And in terms of rights and freedoms, we interpret rights and freedoms to the maximum, to the liberal, to the furthest extent. Not absolute, but that's the ideal, as far absolute as possible. So that's how you read the law of rights and freedoms. I have a right to speak, not just whisper, to the grass, but I got a right to speak. So, yeah, there might be this exception or that exception or what the fuck, but the First Amendment to the U.S. Constitution and some fucking amendment in the Colorado Constitution and the Bill of Rights in Article 2 protects my right to speak. And so, therefore, I have a right to speak. So there you go. There you go. That's just how I feel. And then, according to my calculations, we got about goddamn 70 plus rights and freedoms. And it's responsible. I'd rather instead of hooligans doing hooligan shit, they're redressing the government. They're petitioning the government for a redress of grievances.